Ladies and gentlemen, let me open the symposium formally. Let me also welcome our distinguished guests, the distinguished professors, trainers, and experts that are here, and of course I would also like to welcome the public notaries. On behalf of the National Union of the Public Notaries, on my own behalf and on behalf of our host, I would like to welcome you again and to welcome you in this important symposium. This is the beginning of the year, and that is why I'm also availing myself of this opportunity to wish you a Happy New Year. And Happy New Year's after this one. And I would also like to wish you a lot of accomplishments, both personal and professional. When the President assigned me to deliver this opening speech, which is quite honoring to me, of course that I thought how I should do it. And before deciding what to do, I also thought of what not to do. And I thought that I should not be doing things formally. I would like to tell you that the audience and the panelists are prestigious and famous people. This topic is not formal, but is a practical one. I have participated in many round tables, in many seminars and symposiums, and I need to confess that most of them are boring. They are boring, and they are not necessarily valuable for the notary's practice, but they are in general boring, and they are only statistically valuable. I am a public notary, and we are going to talk about something which is quite up to date, something quite a current matter, and we shall have to issue the new regulation, to issue the European Certificate of Successor, and we shall have to know how we should do it. And I guess that you will be asking some questions, and some answers will come, and this practice will set the example and will be turned into case law. So, for that matter, this topic is quite challenging. Why? Because in Romania, at least, the inheritance and successors procedure is a quasi-notarial procedure. Over 90% of the succession cases and inheritance cases are settled by the public notary, unlike other countries. Statistically, only less than 10% of these cases are settled in court. But for the rest, the procedure is a common procedure, is something that the notary usually does. We can say here that this is actually a notary's regulation because it focuses on something which is quite frequently encountered in our practice. And as somebody said in the previous meetings focusing on such topics in 2013 and 2014, organized by the our union and by the European Union, this event highlights the European dimension of our activity. This is a dimension which cannot be ignored. We are not a countryside notary that deals with some lands and with some conflicts. We have a tangible European dimension. The Romanian communities living in Europe are big, their problems are ever more frequent, and we are going to be facing them ever more frequently. So we are public notaries and we need to find solutions to them. For instance, successions involving foreign elements and are going to be ever more frequent. And when the civil law changed, in Romania, Law 36, well, our union organized such seminars even before those times in order to pave the way. This topic is quite challenging, and the audience matches the seriousness and depth of these issues. And we are going to turn this seminar into a source of wisdom for the next activities. I would like to clarify something as well. I believe that the consortium of the trainers are honoring 3 big universities coordinated by the European Institute of Public Administration. 3 big European universities are here, and they are training us today, which is quite honoring. The fact that the Union of the Notary Public is participating is also honoring to us, because we are part of the legal professions in Romania. We are partners in this program, and for all that, we should mention all of the participants. And also mentioned should be something that Raul Rădoi talked about. He told me, well, you can realize that we are going to meet in this room, and we are actually representatives of the Latin peoples of Europe. We have Spain, Italy, and Romania. So basically, we are speaking our own Latin language. We have the same temperament. We have similar approaches, and Raul's statement has to be sent to you, because this sort of statement is something that is close to our heart. I will not rest my case before thanking to our partners, to our project managers, to Professor Shaguna, the Romanian Notaries Institute, to the team of the Teodor Paladi Conference Center, who is always involved quite passionately in our events. And not lastly, I think I should be wishing you that the next hours should go quite quickly and quite usefully to all of you. Thank you. Hello. Mr. Bogdanchuk, thank you very much for the opening speech and for his availability and for his involvement in our project. My name is Alexandra Danila, and I am going to coordinate today's seminar for the Romanian side. I would like to tell you quite briefly a couple of words about the project that this seminar is part of. This is a wider project which is entitled and this is a project focusing on Regulation 650. This is co-financed by the European Union through the Civil Justice Program and is implemented by the University of Milan. Our institute is also a co-beneficiary alongside the European Institute for Public Administration and the Genoa University and the University of Munich and some notaries institutions from Europe. The project started in 2014 in Rome and will end next year. This is the first meeting. The second meeting, the first one took place in Rome, and we are going to have 2 more seminars in Munich and Madrid, and the closing conference will take place in Milan. The main targets of the objectives are the following: to prepare a guide of good practice and a white charter in matters of successions. Today's seminar is structured in 2 parts. We are going to listen to Mr. Dario Restuccia, Dragoș Isache, Ioana Olaru, Lorenzo Prasaventoza. And in the next part, we are going to focus on some practical cases that are going to be presented by Daniele Muritano, cooperatively with somebody else. I would like to tell you that the questions should be asked during the breaks. After Mr. Isake's speech and at the end of the presentation. That much from me. You are going to get some presentations. These presentations will be available on the website of the project, and I will pass the floor to Mr. Dario Restucciu, but not before reminding the speakers to speak a little bit more slowly in order for the interpreters to keep up with them, but also you should use not more than 30 minutes for your presentations. Thank you very much. Thank you very much. Thank you very much for your invitation. I will try to comply with your instructions. Well, this slide explains why this regulation on international successions had to be prepared. For the time being, every year, about 450 such successions are processed. We have an estimated value of about 120 to 130 billion euros worth of successions. This figure is quite important, and this figure will grow within the European Union. Undoubtedly, this amount will lead to growing cultural exchanges, but also to growing economic and business exchanges within Europe. This will eventually lead to I apologize, he didn't finish his sentence. The gentleman is still trying to figure out the presentations. There are some minor technical issues, and we apologize for that. So I was saying that these growing economic exchanges will ultimately trigger off an increase in the international transactions. The succession regulation is one that everybody has considered to be quite successful. Quite successful to the entire European Union. I believe that it is a success too, but it is quite a victory to the public notaries, because everything started from the public notaries. The public notaries were the ones who took great care of these regulations, starting from the original proposal. Then the European Union processed and complemented this regulation, and the European public notaries played a very important role. So this regulation is surely a success, not necessarily because of the actual initiative, but because of the ultimate result that it will have. So we are now where we plan to be in the first place. The result is quite important. and the result was obtained with a lot of work, especially in the field of successions. A lot of work was necessary because each country has its own tradition, millennium-old tradition. The methods can be different. The way in which the laws are enforced is different. So, faced with these diversities and faced with this very complicated management of our succession traditions, some options had to be reconciled in this regulation, and these options took into account the need to identify the principles that govern successions. So we wanted to avoid the situation where there were several competencies that had to be enforced. So basically what we wanted was some sort of a continuity in all of the member states, so that all of the member states can enforce this consistently. These are the three options that govern the regulation and that have governed the choices that were made and that have led ultimately to the preparation and adoption of this regulation. More specifically, the position is shared more or less by everyone, and we are now at a point where we have essential and fundamental regulations. Let's see what are the regulations and the results that have been obtained. These results are that we can identify a criterion based on which succession can be governed by a single and consistent law. We, in this way, can start to waive those principles that create a lot of cleavage and problems in certain situations. And in this way, we can avoid any delay, endless delays in settling the succession cases. And then there is also a possibility to change the applicable law in the case of a succession or inheritance. And this option in certain cases was provided for, and in reality, taking into account this opinion according to which citizens have to interact more among themselves, the wish was to avoid several procedures that were different from each other. So in the old days, there were people ran into situations that generated very serious conflicts over succession then, because the same inheritance was treated differently depending on the different jurisdictions that were involved. Now we have a new outlook of the European Certificate of a Successor, which is quite new. Romanians do have such a certificate of this sort, or something similar. This sort of certificate, European certificate, is something that we need to consider quite carefully, because it is different from any other certificates of inheritor that have existed so far in Europe. So there's a so-called certificate that derives from the system of the laws that the Austro-Hungarian Empire used to have. The aim of the certificate is to reach different targets. We need to consider that when the regulation was prepared, there were two ways. According to one of these ways, this European certificate of succession, well, this certificate of succession has to play simply a role of a proof. But the opinion of the European notaries was that we need to set for ourselves a number of targets, reachable targets, because in this way people could have their European certificate of succession. If the aim had been too high, then it couldn't have been reached. So we didn't want to get there. We need to take into account the principles of law. It is not mandatory to have this certificate, though, because probably this certificate is not capable of covering perfectly all of the jurisdictions. The systems are always very complicated. And the aim was that this new European regulation should not turn everything upside down, because systems are anyway complicated. The idea was not necessarily to harmonize the existing systems, but to create a new parallel system, a new European certificate of succession, a new system, I was saying, with a new enforceable law and a new enforcement guideline, and a new way of identifying the jurisdictions. This is the basic document that will be used and that will be interpreted. I'm not looking at my emails, I'm looking at my time watch. I'm trying to keep my time. So everything has a turning point. These turning points are complex moments, difficult moments. But we all, the people who are working in this particular line of work, are making every effort to solve things successfully. This big principle of unifying the laws, or of enforcing a single law, is covered by Article 29 that provides a derogation. Article 29, well, provides for an exception to this norm. Article 29 is actually an invitation, if we can put it that way, to UK and Ireland to adopt this European norm and regulation. And that's one of the reasons why my slides are in English. This is an invitation to UK and Ireland to adopt this regulation. Article 29, I was saying, is related somehow to UK and Ireland. Why? Because this article refers to the member states whose legislation involves the involvement of a judicial administrator or a receiver or a trustee, and enables one of the states that has a jurisdiction in this line of work to assign one or more of these administrators according to their own national law, in spite of the fact that the law which is invoked has to be has to apply to inheritors when it comes to successions. Under point 43 of the preamble, if I remember well, I'm trying to find it. Well, according to this particular point, the competence norms laid by this regulation in certain cases lead to a situation where the court will not be applying its own law, but in order to facilitate the coordination in between the applicable law and the member state law that has jurisdiction, the member state should assign one or more persons having the right to administer that succession according to all applicable laws. This corresponds to a practice which is already in existence in some countries such as UK, and which consists of enforcing a certain grant of probate. This is a benefit of the inheritors, those that have the right to the succession. So this is a derogation that enables people to resort to these instruments. So this is just an introduction to some of the issues that will be debated today. And probably these issues will be complemented by the questions coming from the audience. Questions that have already been asked. Some of them were asked the other day. So this is a political choice when it comes to this sort of residence. This is the consequence of a policy that wants to prevail over the national principles. Why? Because the aim is to break all of the barriers separating the member states, and it starts from a principle according to which nationality has to be abandoned. The principle of the habitual residence is not very clearly defined, and this topic is quite interesting, and it will be debated by specialists. There are some concrete cases, tangible cases, in which it will be very difficult to establish the so-called habitual residence. Marco Moritano will be trying to present some cases, and you will see that establishing the habitual residence is usually quite a difficult thing to do. And of course, the concept or criterion which uses and which refers to habitual residence is very clear. In spite of all of the difficulties we have in using the valuable circumstances in supporting people's lives, well, in spite of all these problems, we definitely need to be very attentive to how we apply the habitual residence principle. This is something connected to a certain policy of the European Union. Another problematic issue is the clause under Article 21, paragraph 2 of this regulation. So Article 21, paragraph 2, according to which an escape clause can be invoked. Well, there is the habitual residence on the one hand, but on the other hand there are options in exceptional circumstances to consider that the deceased at the time of the death had closer connections with another state than the state of residence. But this problem will be covered by somebody else, so I'm not going to get into the details right now. Now, about this particular argument of the habitual residence, I gotta tell you that this is a clause, an exception, that results from Article 21, paragraph 2, that could generate a number of negative consequences. So this is a weakness, a weak point of the regulation, because it doesn't give us any certainty when it comes to the law that has to be applied to succession at that particular point in time. And identifying the proper law is instrumental to handling successions properly. So if there is any doubt about this article and about this concept, then the person who's supposed to plan and to process this succession then is faced with a lot of problems and a lot of complications. The last issue that generates problems, and I guess I should be stopping here because I'm running out of time, and I should only cover 4 points. There are many others, but this is what I can do. It's, well, getting back to my speech, Ioana, our colleague, will talk about this problem, the fact that Article 22, paragraph 2, comes up with an exception, or not necessarily an exception per se, but an option to resort to a iuris tacita procedure. This happens when the choice of the law is influenced by the context of the dispositions regarding the cause of death. You will see how complicated this is about these dispositions, because nobody thought of how the disposition upon property upon death is going to be handled. So nobody could think that somebody's succession would be regulated so strictly. But somebody may want to transfer to Spain, for instance, to work. And once in Spain, that person understands that he would like to spend the rest of his life there, in Marbella, in Spain. So, choosing the applicable law in these testamentary dispositions is a little bit connected to chance. Of course, that these choices are very hard to express. It's difficult to tell whether this is about choosing the law or other factors. If it was a matter of personal choice, maybe the people could realize that the enforceable law could not allow him to make a certain choice. Probably and hopefully we will find an answer in the practical approach. To me, the real problem is that this regulation is one, the purpose of which is to regulate the successions and inheritances that cross the borders. These are the so-called cross-border successions. What's happening? What happens to the internal successions that do not comply with all of these criteria? In my mind, discrimination, reverse discrimination appears. These are forms of discrimination in which the application of the European norm or the non-enforcement of the national regulations create some sort of a discrimination. within the bounds of the European Union. And in the European Union, the forms of discrimination associated with nationality are banned. But there are European citizens traveling around, and their business, their activities involve some foreign elements. They have, for instance, one little house, one cottage in the countryside somewhere. But whoever is not connected to these foreign elements doesn't have a problem then. Or he or she may be subject to a so-called reverse discrimination because they are citizens who are discriminated because these elements are not there. This is a principle which is to be found in all of the documents of the European Union, in all of the charters. Well, you guys in Romania already have a certificate of succession.
Think of other countries like Spain, Italy, in which the proof that you are a successor relates to a document that is a, let's call it notoriety document. So the document says that that person is the successor. In France, the situation is a bit different because the latest change to the law stipulates something different. However, the document attesting to the inheritance has its limits. Because, as I said, the situation is different compared to the certificate of succession. So therefore, I believe that in the future, states will accept the European certificate of succession for internal succession as well. This also because, and allow me to make this my final remark. So think of this. The cross-border details are just in, in appearance, are just in imagination. Also, imagine a Romanian citizen coming to you, asking that you draft a certificate of succession, saying, and asking why, because, well, I have a loan, I took out a loan in Italy. No, the speaker says that I have to recover money from the tax agency in Italy. There are cross-border implications in this. It is correct. It is important for a certificate of succession to be issued. I will issue a European certificate of succession. The Romanian citizen goes back to Italy and discovers that the right exceeded the statute of limitation, the right of receiving money from the tax agencies. Therefore, this European certificate of succession, according to the regulation, once issued, it can be used also in the country where it was issued. So basically this is an inheritance that doesn't entail cross-border implications. The European certificate of succession was issued without any type of consequence for the issuer, because when the notary or the respective authority issues that certificate, this was according to the law. There is no responsibility as a result of issuing this document. And of course, it might be possible, based on this quite banal argument, to follow up on the enforcement of the certificate, also relating to inheritances that do not entail the cross-border implications, so as to avoid the reverse discrimination. I think I met my time, so thank you very much for your attention. Thank you, Mr. Dario Restuccia. We will now hear from Mr. Jacopo Re on the residence as per the regulation. Thank you, Alexandra, Irina, and that's pretty much all the Romanian I know. I will now continue my presentation in Italian. Thank you, Mr. President. Thank you, organizers of this seminar. Thank you for the invitation. Now, tackling a fundamental issue, Regulation 650 per 2012, or about habitual residence. Habitual residence is the fundamentally is the corner mark and the cornerstone of the benchmark of the entire regulation, because the judge has to determine the regulation between the two to find out the applicable law for international successions. So you have these two sides and one main important link. You have to be very attentive when applying the regulation not to mix this warning with the function, the use of the habitual residence under the competence, and with the applicable criterion on determining the applicable law, because a judge on the applicable law, because the judge will try to continue on and to apply own competence, but it could also tackle the habitual residence term on the decrease, on the deceased, in order to determine the proper succession. So you would have, on the one hand, the deceased, taking into account the habitual residence, and a judge applying this term, trying to expand it so as to enforce its own jurisdiction. Of course, there are certain consequences. Once the judge has determined its own competence, it will proceed to implementing the law that was not the initial one. So, mind you, in not confusing the two elements and taking into account the characteristics and of the regulation and the applicable law, which in this case might differ. My presentation will be twofold. The first regards the habitual residence. How do we determine the habitual residence, and which are the objectives of the European Union on adopting this criterion? And on the second part, the role of the habitual residence with respect to the deceased and with respect to other parties interested in the succession. So how do we determine habitual residence? There's no real definition for it. There's no legal definition of habitual residence. This is a fully fledged term within this regulation. And this means that we shouldn't interpret it through the law of that respective member state. It is, as I said, a flexible criteria, de facto, that entails acknowledging or recognition the connecting items in the respective situations according to certain regulations and determining where is the main focus of this case, and that's where the habitual residence of the deceased shall be. For this, we have to adjust and to adopt a functional interpretation of the regulations, of the principles, of the possibility that the succession be tackled legally according to proper regulations. Another objective is to take into account this parallel between the users of the regulation. You have the judge applying the own law and the other parties in order to determine the habitual residence. Fortunately, the regulation does provide certain guidelines. We have to take into account Article 23 and 24 in the Regulation 650. Now, prior to getting into detail, we have to take into account that habitual residence is a linking criterion used in international conventions of private international law, in the regulations of the European Community and European Union of private law, and in documents of the above-mentioned institutions. What does this mean? Can we use one interpretation? Well, no. As I said, the interpretation has to be functional. It has to depend on the objectives and on the document that we apply. And for this, we have to take into account the regulations of Regulation 650. We cannot use the case law of the Union and of the European Court of Justice that interpreted habitual residence in other legal frameworks as law. The habitual residence has to be interpreted constantly and consistently, but it cannot be used just through 650. Of course, there is no decision of the European Court of Justice in this respect right now. Therefore, we apply the regulation for these successions to be tackled after August this year. However, the principle is quite the same, as I already stated. Observing the regulation for the private law documents according to norms 523, as the European Court of Justice mentioned. The important detail of this judgment from the European Court of Justice is that we have to assess the habitual residence of minors, referring here to Article 8, according to the competence with respect to divorce and separation, and on where the habitual residence of the minor will be, according to the decisions of the European Court of Justice. So that's quite clear. On the other hand, we could also think about how the court interprets the term of habitual residence in documents that have the same approach, documents in which we use and tackle various cases. In order to determine the habitual residence of a minor, we can refer to the competence of the European Court of Justice with respect to Regulation 2100, says the Speaker. We also have to mention the regulation from the perspective of determining alimony. Which are the particular practical tools to determine habitual residence? What do we have in the lack of a definition? We can refer to the Boras report. This explains a convention that was never put into force at international level, but which was useful prior to the entry into force of the regulation, if we speak about Regulation 2100. Madam Boras says that the habitual residence is in the town where the residence is to be set through own will, and this can be the permanent center of interest. And for this, it's important to take into account all details that comprise to this habitual residence. This is a first indication, let's say, on how we could determine habitual residence. Another important indication, of course, of a different kind. Nonetheless, they are an integral part, so they are mandatory. Taking into account Article 23 in the regulation, referring to how we can determine habitual residence, and given the parallel notions of use and form, we can determine the residence after a global assessment of the life of the deceased in the years prior to life and upon in the years prior to death and upon the death, so as to refer to the pertinent details, which is the duration, regularity of the residence of the deceased in that state, and also depending on the conditions of the state. But we should also take into account the interpretation rule, so as to have a tight relation with the interested state, taking into account the specific objectives of the regulation. Well, there's not enough time to make a clear difference between the two instruments, let's say. The Boras report on the one hand and the Consideration 23 in the regulation, because Boras stresses on the will, the desire of the interested party, the reasons for determining habitual residence in that country, and we will get to this detail later on. But if we come to 23, this gives us 3 guidelines on determining the habitual residence. Previously, so previous to the death and upon death. So duration and conditions of living. And of course the purpose is the same, to conclude on where is the habitual residence. I've tried to somehow draft a chart on the criteria that could lead to the habitual residence. First of all, taking into account that the habitual residence consists in 2 main parts: the duration of living in that state, and the will, the animus manendi. Now, of course, we have to understand which are the items that amounts to this concept. First of all, the actual residence of living. The second would be the personal relation of the deceased, where the life, so where he lived, where he or she carried out the personal or professional activity, and of course we have to take into account all of these perspectives. And of course assets, movable and immovable goods, bank accounts, financial instruments, whether the money was cashed by the family or not. So all these taken into account, various territories, and correlating all these items so as to lead to the habitual residence. But we also have to take into account the language that the deceased spoke as a single membership or belonging to a culture. We also have to take into account the citizenship of the deceased. So it's like you're on a geographical map, and you have to know where you place the habitual residence, the personal relation, the professional relation, the assets, and of course, the more scattered the points are, the more difficult it is to determine habitual residence. Nonetheless, we have to find one, otherwise it's not enforceable. The regulation cannot be enforced, and there's no objective criterion on selecting the applicable law, because if the deceased did not have a certain profession, did not select citizenship according to a law, we cannot find an applicable law for that succession. So irrespective of how scattered these points are on the map, we have to find a habitual residence for the deceased. So how do we do it? According to which argument? So let's say if you have 5 personal relations in country A, 5 personal relations in country B, let's say, or you might also determine on the type of the deceased relation. So we have to assess the importance of these points on the map. Points depending on the relation, of course, and we have to take into account the main events in the life of the deceased. So this is a table that I've tried to use to show the map that I mentioned, but of course there are particular situations that each legislator will determine depending on the particular case, per case. The deceased lived, let's say, similarly in 2 or several countries, living in each of them successively. So a period in Romania, another period in Italy. So how do you determine, in this case, the habitual residence? We have to make use of the citizenship, the level of belonging to a culture. We have to wonder where the assets are located. And we have to see if they coincide with the inheritance. And then we can determine where the habitual residence is. Or the deceased may have lived somewhere else for a certain period of time, and for working, for illness, for studying, but had a very tight relation with the country of origin. And in fact, this person was a citizen of both countries. or even spoke both languages. So we can say that the habitual residence can be determined according to the will. As we will see in the afternoon, we will tackle many practical cases. There's no mathematical formula to determine the habitual residence. There's no perfect formula. However, it does give the possibility to the officer to take them into account. Do I still have 10 minutes left, Madam President? No, just 8. Okay, thank you. Well, there's also a set of policies that led us to select the habitual residence. I will try to briefly go through them. So let's call it the center of interest is important of the deceased, the expressing the will, the criteria, the connecting criteria in European law. There's each legal system will apply to the citizens that reside on that state the same legal principles. Several jurisdictions, several applicable laws, but this is good because you can find coherent solutions. We can use a public legal system. If regulations are approved, let's say relation between the spouses, we could find a coincidence between the applicable law if there's no specific selection, in the sense that the law used for the succession might be a mixture of the two, and we can also determine on the advantages of using this approach. You could also face fraud, so parties trying to fraud the law on a future succession. One country determines one thing, but another country might determine something else in a fraudulent manner. So the regulation, through argument 26, tell us how to solve the situation. A last disadvantage, the successions that are not completely within the community or intra-community. If the residence of the deceased is outside the community area, then we have to start all over again to see which is where is the habitual residence, and it's very difficult to see which regulation applies. Well, these are a few of the characteristics of the habitual residence, because it is very important how this is determined. Well, should you have questions, I'm more than happy to take them on the role of the habitual residence within the regulation. As I said, the law, the applicable jurisdiction, let's have to see what are the norms, the guidelines through which we can apply them. Argument 4 in the regulation is very important, saying that in order to regulate this, the judges in the state where the deceased had its residence in are those competent. So this applies to the jurisdiction but not to the competence. And let me tell you why. If I determine that the residence is in Romania, because he or she had a house here, so one house in Constanța, one family in Cluj, and working in Bucharest, so all over the country. Of course, according to the Romanian procedure code, we have to we have to conclude that the jurisdiction that is enforced is the Romanian one. Well, you can also find the slides in English if this appeals to you. There's also the auxiliary jurisdiction or the subsidiary jurisdiction. In the last residence of the deceased is not in the countries that have to observe this regulation. And if the deceased had the last but the least residence in that country for 5 years previous to the death, the judge in that country can determine as habitual residence by subsidiary jurisdiction that the habitual residence is on the territory of that state. And a last comment. The habitual residence as an objective criterion. The entire succession is regulated by the law in which the deceased had his or her habitual residence, and this has several implications. If the law is applied in a certain state, then there can be issues with the legal systems in various countries. What happens if the deceased had the habitual residence in the US? Of course, the American legal system has to apply. Article 21 in the regulation, for example. Let's think about that. Those provisions. The habitual residence is very difficult to determine, all the more if the connections of the deceased were scattered in several countries. So we have to find an average between all these points so that we can determine the habitual residence. How to use the same criteria so as to say that in another country there were tight relations compared to this country. So I didn't really understand how this guideline should be used, and there has to be a debate on it to find a particular case in which we can use this escape clause. As I mentioned, the habitual residence is regulated by other pieces of legislation as well, but unfortunately my time does not allow me to get in detail. So maybe a last comment. It's not just this regulation covering the habitual residence of the deceased, but also the habitual residence of other parties. In Article 13 and 21 refer to this. So accepting or giving up the inheritance, and if, of course, the party wants to accept or waive from the succession. And in this case, this is very important with respect to the succession itself. Now with this, if I may conclude, and thank you for your attention. Thank you for the full and interesting presentation. If I now may give the floor to our colleague Dragos Isake for a presentation on the link between the Regulation 650 and the international private law.
Welcome. To start with, I'd like to ask some questions that should be the starting point of the topic and that should synthesize the range of issues that we are faced with. What is the European context in matters of succession of the conflictual norms of international public law of the member states and of the positive norms? And then, what is the purpose of Regulation 650? What this regulation will not be able to do? And once this regulation is on, what will be the place of the international private law in succession matters in member states? Probably there are few other areas of the civil law that cover such a diverse range of issues. The national laws in succession matters and in estate matters, but also the private norms, international norms, the conflict-related norms are expressions of the traditions that each country has, or unfortunately expressions of legislative inertia, unfortunately, and they reflect the interest that at some point every state attaches to one issue or another, thereby justifying the option for a different legal solution. The classes of successions, the shares, the situation of the surviving spouse, the nature and extension of the successor's reserve, the estates, the testamentary contracts, the shared wills, all of these are issues that national legislations handle quite differently and diversely. We have assisted to the adoption of a new civil code in the past years, and we could see how powerful tradition is. This is manifested through the fact that the dispositions covering estate law and the pact upon unclaimed estates and the wills have remained unchanged, while others have seen some sort of a reform. From that perspective, we need to say from the very beginning that Regulation 650 is not aimed at unifying and making consistent the European material law and the succession law, the inheritance law, but the countries are still free to handle these issues as they wish. There are some material issues that this regulation regulates and that prevail over the national regulations. Even if these issues have an exceptional nature, they still have to be considered and observed. And this is the case of adjusting the rights in rem, the comorientis, and the inheritance law. Article 31 of the regulation says that if a person invokes a right in rem, that it has the right to, and if the law of the member state in which the right is invoked does not know the right in rem in question, that person will, if necessary and to the extent possible, according to Article 31, so that right shall be adapted to the closest equivalent right in rem under the law of that state, while taking into account the aims and the interests pursued by the specific right in rem and the effects attached to it. The regulation does not cover the rights in rem. This results from the very clear presentation of the framework article, and it also does not mention the numerus clausus issue. So the rights in rem and their extent are covered and handled according to the national law, but this regulation still covers the transfer of the estate to the inheritors, so that the liquidation of the succession will influence the status of this estate. There is a possibility that the inheritance law, which is unitary and consistent, should assign the character of a right in rem that the law of a member state or third party knows. The right in rem may cover an immovable property, a movable property, or types of goods. If the way in which the succession is to be handled is known to the state where the European certificate of succession is claimed, but that has another legal content, but not one running to the contrary, then Article 31 cannot be invoked. The mechanism of the adjustment instated by Article 31 is also very well known to practitioners of international law. The second thing, which is an intrusion of Article 650, is the commorients issue. If one or several people whose successions are regulated by different laws, and here we have some conditions based on which Article 32 should be enforced, die in circumstances in which the order of their deaths cannot be established clearly, and if there are no provision to handle that, none of the deceased shall have the right to the other's estate. So, in the legal issue of the commorients, there is a problem that we have found. I'm talking about the fact that in some states there is an assumption according to which people are dead at the same time, and therefore none of these people may claim the other deceased estate. In the other countries there is a different assumption according to which the oldest person died the first. The problem of the commorients is associated to the time of the death and to the capacity to inherit, and these are regulated by the inheritance law. In order to apply Article 32, three conditions have to be satisfied. The impossibility to establish the order of the deaths, that's the first one. The second one is that the situation should involve the inheritance of several people governed by several jurisdictions or laws. And the third one is that the different laws should be in contradiction to each other in these issues of the commorients, or should not provide any regulation. If these conditions are satisfied, then based on this regulation, none of the deceased shall have the right to the other deceased estate. Another intrusion in the material area is the so-called vacant succession or unclaimed succession. If there is no inheritor or any successor for the estate which is covered by disposition of property of death, then the law will not will not entitle anybody to get under its own law the property in the of the estate that is located on its own territory. And this is necessary after the sharing, provided that the creditor should have the right to claim the extinguishment of the debts. The difficulty of the international succession is in this respect, it consists in the fact that the succession law is not identical. There are two systems. In one system, the state is considered to be a sui generis inheritor, while in the other system, the state takes over the estate based on the sovereignty rights. The inheritance law will establish what a vacant inheritance is. Article 33 covers two rules. In one phase, it is still the inheritance law that will establish the fate of the estate, more specifically the successor's capacity of the state. In case of conflicting legal successions, the regulations entitles the state where the estate is located to apply its own inheritance law covering the estates that have not been claimed. So the creditors are protected in this way, and they can take that estate to cover their own outstanding receivables. Secondly, the regulation includes a very detailed regulation of the European Certificate of Succession and establish the conditions in which this should be released. The template, which you have seen for sure, and other forms have already been established by means of the Enforcement Guidelines 1329 issued in December of 2014. When it comes to the conflicting norms governing inheritance, well, right now member states have a different perception about the nature of the succession. Some countries have a unitary system, while others have a dualist system. This dualist system involves the latest known place of residence. You know that Romania had the dualist system under a law it used to have that regulated the legal relationship, and the Article 66 of that law regulated these issues until a couple of years ago, when the new civil code appeared, because the new civil code has a special chapter devoted to conflicting norms. The unitary system applies the unitary law and the unitary principles, but even so, some countries prefer citizenship, but other countries prefer the place of residence. The problem of choosing one or the other law complicates even more matters that are complex enough, because some countries admit that and other countries reject it fully. The newer European-wise regulations are better. Our civil code adopted the unitary system and invokes the habitual residence principle, and you can see here on the screen our article. From that perspective, the merit of Article 650 is that for the first time it ends this diversity and introduces rules of international private law that are consistent and uniform throughout all of the 24 countries that have adopted this regulation. Denmark, UK, and Ireland did not accept this regulation, but they are still able to use it in the future. So the regulation covers all of the problems associated to inheritance, and we are talking about conflicting laws and conflicting jurisdictions. For the future, the unification of the norms that govern conflicting laws and conflicting jurisdictions could be the starting point for a certain convergence of the national inheritance laws. The regulation relies on a clearly liberal philosophy, starting from the autonomy of the parties, that could make national law more flexible when it comes to things that are rigidly handled right now, such as the testamentary contracts. So jurisdiction and applicable law should coincide. In such a case, in most cases, the authority that should handle the inheritance should apply the law of the forum, so its own law. That happens when the jurisdiction and the enforceable law rely on the habitual residence of the cuius. The law associated to Article 21 of the regulation governs all of the estates, So the unity of the estate gets its inspiration from the national laws. We note, to begin with, a unity as related to the estate, regardless of what they are. Outstanding receivables, outstanding payables, or movables or immovables. The inheritance law governs also the liabilities. The regulation rejects the dualist approach, which is right now in compared law in many countries. The characteristic of the dualist, of the dual capacity, is that they superpose a number of things. In most cases, they do not invoke the law of the last residence. The dualist approach has the merit, when it comes to the immovables, that it challenges the application of one consistent law when it comes to inheritance and also when it comes to the rights in rem, thereby ensuring a consistency and a continuous treatment. But that benefit is strongly influenced negatively by the major inconvenience associated to the territorial sharing of the succession if the estate covers properties located in different states and that are handled differently according to the different jurisdictions. But there's still a consistency when it comes to the material domain, which is quite extended, because the syntagm overall estate, that covers both the succession and also how it is to be handled and how it is to be extinguished. The regulation also covers for some differences in how the law should be applied. One example is the mortis causa, because the law that governs the admissibility, the conditions and the effects are established differently from the inheritance law according to Articles 24 and 25 of the regulation, out of the wish to ensure some stability to people who organize and handle their succession during their life. These are hypothetical issues. And that happened to people who may have died on the death when they were supposed to prepare their will. The consequence is that the habitual residence is established in a different state. The problem that refer to the admissibility and validity and the effects of the testamentary contracts are already known in practice, because of the fact that these sorts of acts are banned in numerous Roman law-based countries, such as Romania, but they are valid and frequently used in Saxon states, German law states, so that the determination of the law applicable is quite difficult. If the testamentary contract is validly prepared according to the law which is established as per Article 25, then its effects need to be recognized in all of the countries. And these countries cannot invoke the exception of international public policy. Another example, which is quite exceptional, is Article 30, according to which the law of the place where the estate is located may be applied, unlike what Article 21 says. So, if the law of the state where certain estate is considered, some companies or other special categories of property, invokes some special rules which for economic, family or social reasons establish restrictions about successions or affect the succession about those estates, then those special norms shall apply to the inheritance insofar as, according to the law of that state, those norms are applicable regardless of the law which is enforceable upon that inheritance. That law that text brings some exception, and it will be used quite rarely. It is focused on the agricultural holdings, which, according to some laws, especially the French ones, are covered by special laws if the death of the owner or of the user appears in order to guarantee the continued exploitation of that holdings. So it also covers some other companies and some other specialist states, but all of these things are not clearly clarified. Somebody also thought about copyrights. Copyrights to which internal law gives a special and derogatory legal content in the case that the main holder dies. The Romanian norms that are conflicting in matters of successions, just as you know, are to be found in Book 7, Title 2, Chapter 4, Articles 2633 to 2636 of the Romanian Civil Code. The conflicting norms are also to be found in international treaties or bilateral treaties that Romania has signed with member states or third-party countries. Given the Article 75 of the regulation, as of August the 15th, 2015, we may make some distinction when it comes to their application in time. The conflicting norms of Romanian international private law mentioned in the Civil Code will no longer be enforceable in the inheritance cases in which the deceased, who are citizens of the member states or third-party states, died after the 17th of August 2015. The conflicting norms that are covered by the Civil Code in matters of successions will still be applied in cases where the deceased, members of member states or third-party countries, died before 17th of August 2015. In the case of a death of a member, in the case of a death of a citizen of a member state, after the 17th of August, if Romania and that state has a bilateral agreement, that agreement shall no longer apply and the regulation shall be enforceable. In the case of the succession of the citizen of a member state who died before the 17th of August 2015, if Romania and that state has a bilateral treaty, then this bilateral treaty will apply. If in the case of the succession of a citizen from a third-party country, regardless of when he dies, if Romania and that state has a bilateral treaty, then that will continue to apply.
Now, with respect to what the regulation does not want to cover, there is a list meant to be exhaustive with respect to the areas that the regulation does not cover, where the conflicting norms of the states shall apply. It's the areas according to Article 1, Paragraph 1 and 2. You can see actually the list. There are very many fields not covered. You can see, first of all, the tax, customs, and administrative matters. Nonetheless, some of these matters are interesting to handle a succession. And we speak here about the asset of marriages, about the absences of the party, about the capacity or death, about the nature of the real right, about enlisting rights of ownership on certain assets. And these will be solved according to the norm by the private international law of the member states, if applicable, of other European regulations. Now, this, of course, separate from the succession law, as if that was the main issue. Nonetheless, since 1960s, there has been a German trend suggesting to try the previous details as an accessory, independent from the succession law, providing a uniformity of these solutions. Although the intention of the regulation is that the justice apply as succession law the own law, there are also cases in which the forum has to apply another law to the succession law. Case of selecting the succession law of a third party according to Article 30, or as we shall see most frequently, the Romanian notaries. Between the foreign law and the applicable law, a foreign law, there might be differences, and we refer here to the international public order, provided according to Article 35 in the regulation. What is this international public order? What is the content? How is it determined? We are now interested in the succession reserve. Article 35 somehow referred similarly to other European regulations, the public order exception. We noticed that the foreign law cannot be applied in any situations, but only when it is incompatible with the public order of the forum. Therefore, the exceptional matter or nature of this norm. So we have to compare the forum public order and the international public order on the other hand. A pure abstract comparison is impossible to do, and the incompatibility with the public order of the forum has to be made in clear cases compared to the effects that should be shocking, says the speaker, which the foreign law could cause in a certain case. In certain situations, the link of the author with the succession can be tighter, so the habitual residence or the latest residence, or it might require a specific research of each case. And this order can be invoked depending on the discrimination of religion, gender, and the order that protects the fundamental rights, and therefore the European Charter of Human Rights, acknowledged with the treaty by the treaty in Lisbon, now applied as a treaty itself, can be an essential, main reference as the European Convention of Human Rights. So not yet, although not yet ratified by the European Union. Now, the exception, however, is a controversy, or raises controversy. Is this succession reserve a fundamental, universal value? In the past, certain institutions said that this does not infringe on the forum. But the French doctrine is different because two large professors sustain the contrary. Adam Rivière states that the reserve is not an international public order, whereas Professor Grimaldi supports differently. Moreover, the French Senate has adopted in 2006 a resolution according to which the French government had to monitor and to supervise that in drafting Regulation 650, they should make sure that this institution be observed. Nonetheless, a foreign law in which a succession reserve has a different nature, like a rights of receivable and not part of the inheritance, or there are other categories or other values of the reserve, cannot contradict the law of the forum. Now, separate from the reserve, the public order exception could also intervene when, for example, the foreign law does not know certain cases of non-indignity, or when the institution the replacement institution awards succession rights to the spouse of the same-sex spouse or to the concubine. In this case, we know the position of the Romanian legislation that traditionally rejects these values as contradicting with the tradition of family. Thank you, and that is it for me. Thank you, Notary Dragosisake. Should you have any questions now on what was discussed at this first part? So we are taking questions from the audience. If there are no comments, I will ask questions from the Italian partners, and I will ask the speakers if and should they want to answer to them. Of course, they are invited to. This is the first question. So the first question. Given the date of the entry into force of the European regulation with respect to successions, what are the consequences of the statements of selecting the applicable law prior to 17th August 2015? This question was to be tackled by the following presentation that was actually focusing on the applicable law. The transitory provisions of Article 83 in the regulation provide the solution to this question. Of course, the condition is that this statement be drafted on the date of entry into force of the regulation, and provided that the death happened after August 15th, and one statement of selecting the applicable legislation will be validated either according to the provisions in the regulation or according to the international private law provisions applicable in the state of residence of the deceased or in its state of citizenship. Thank you. If you have clarifications, if you need clarifications or other comments? No? And another question somehow related to what was discussed so far. I think Jakob already answered broadly to this question. It's the entire topic, but if he wants to add anything, of course. The question is, how can we identify the habitual residence for people that change their residence, they switch residence to several states due to professional reasons throughout their life? Thank you for the question. Of course, this is one of the cases that I have already mentioned in the presentation, but of course I would like to remind the public that the links that we have to determine in establishing the residences, the domiciles, the role of citizenship is important. Just as important is if we have this several locations when determining the citizenship, location of assets, and of course for the habitual residence we have to take all of this into account. Thank you, Jacobo. If there are no other questions, or if there is no other need for comment, yes, so if there are no other questions, we will now go to the next presentation. Then Madam Notary Ioana Olaru shall sustain. Hello. My presentation regards the selection of applicable law and will. First of all, the general rule is the one stated by Article 22, because you don't have the text of the regulation with you. If I may remind you that according to this article, a person can select the law to be applied to its succession. First of all, this law shall be applied to the succession overall, or as a whole, meeting one of the questions, whether a person can make choice of the legislation to part of its succession or to a certain category of assets. The answer is, of course, no. If the person makes a statement to choose the applicable law, this law will govern the entire succession. You cannot choose different laws depending on the location or the category of the goods. This choice, referred to as professio juris, makes that the law, once known, to be predictable, and of course manages to simplify the succession procedures that might be entailed. And if the deceased changes a residence from one state to another, or changes citizenship, these changes shall not cause effects on the applicable law that was already chosen. You know the current provisions in the civil code that allow a person to make choice of its citizenship law as a law for the succession. The novelty of the regulation is that an individual can also select a law of a citizenship that they may have in the future. Of course, provided that the citizenship be applicable upon a time of death. What happens when the chosen law is the law of a third-party state, or when the succession is to be handled in a third state? If the choice of law is the law of a third state that does not allow for the possibility of such a choice, the choice made is still valid according to argument 40. If the law of the third state allows the choice of the applicable law, in fact, there are no practical difficulties, but we will have to notice that in this situation as well, choosing the applicable law might be limited by certain provisions in the legislation of the third state on the reserve. And if I may give you an example from the Canadian legislation from Quebec, Article 3099 stipulates that such a choice of the applicable law is invalid if the selected law deprives the husband or the partner from a civil union or a child of the deceased from the succession or from the reserve that they might be entitled to in the absence of such a choice. So, if the competence falls under an authority in Romania and the applicable law of choice is a foreign law, any foreign law, we do not have this issue because the Romanian law allows for the reserve. This is a legislation in which the reserve is quite accepted. But for states where this reserve does not exist, for example France, the choice of another law, of the citizenship law that stipulates for the reserve share, can lead to certain situations in which this choice might be limited. Now, this situation, if I'm not mistaken, also exists in the Italian legislation in Article 46, right? Yes. Let's say to a certain extent. All right. Maybe under questions you might give us some clarifications of how it works, but after I finish the presentation. With respect to this choice of law, we have to state that it has very material consequences for the practitioner to process the inheritance, because we will no longer wonder about renvoi, for example. If we don't have to select the content of the foreign law, and we will no longer have to study the mechanism of renvoi of level 1 or level 2 allowed as per the regulation. This selection of the applicable law shall be modified by the exception of the public law that was presented previously, and because it is more difficult to change fraudulently your citizenship just to not have the legislation from your habitual residence state apply. On the deceased with several citizenship, the regulation does not grant priorities to any of them. the deceased can select any of the laws of his or her citizenships, even if the selected citizenship is from a third-party state and the person also has a European citizenship. The latter will not be a priority. And it can also choose a citizenship that is not the citizenship of the state where the individual has the habitual residence. With respect to how the person's residence is determined, argument 41 in the regulation determines that citizenship or determining citizenship is preliminary to be handled depending on the international private law of the forum, or depending on possible conventions that the forum or the state that is informed on is part of. If the chosen law belongs to a state with several territorial units, such as Spain, in order to determine the applicable law, one makes use of the guidelines in the state with respect to contradictions. If this does not exist, the territorial unity law shall be applied with respect to which the deceased had the tightest relation, and the deceased cannot determine directly the law of the territorial unit to be applied. So an individual make a will according to which to select the Spanish law for enforcement, but it will not be able to allow to make a will according to which the law of province X in Spain is applicable. So this will not be possible. The preference of the regulation somehow goes towards the citizenship law. Although the Hague Convention is broader than that, the example was not followed. The deceased cannot select another law of the habitual residence or the location of certain immovable assets or the marriage law. Thus, in a complex succession, a notary might apply several laws. On the one hand, the law of citizenship, selected by the deceased, if applicable. For the marriage, depending on the international private law, the habitual residence of the spouses, most likely. For determining the content of the in rem, the law on the location of the assets. The statement of selection of law has to be specific or tacit, resulting from such an order. If you read Article 3 in the regulation, you see that it defines the provisions on cause of death and the succession agreements according to its Romanian translation. Maybe the translation in the regulation, I would have preferred it to be ad literam, but this was the choice of the translators. So the provision in its official definition includes the wills and the agreements on a future, on a succession, as translated. And the choice can be embedded, can be in the format of a statement with respect to the choice itself. Now, if the choice of the applicable law is as a provision for death that is not known by the selected legislation, although this might be applicable, although the form it has might not be chosen. So let's say very, very specifically, if a Romanian citizen living in Germany makes a succession agreement with the wife as a contract, selecting as applicable law the Romanian law, the succession will be processed in Romania. the succession agreement, is not acknowledged by the succession agreement, so we have to choose one of the versions if this choice continues to be binding or not. As far as form goes, this provision will list under one of the provisions of Article 27 in the regulation, which does not cause practical issues. What happens in the case of a tacit choice of the applicable law? And since at the first presentation, I think this was already tackled, if I may draw your attention on certain elements. On the one hand, a notary authenticating a will for a deceased Romanian citizen, authenticated according to the provisions in the Romanian law, which is the citizenship law, that all clauses observe this legislation, we have to wonder whether by using a national notary with reference to the Romanian law can be a cause for concluding that deceased that at the time of death has the latest residence in Italy or Germany chose and understood to choose the Romanian law as the applicable law for the succession. Given this tacit choice, the interpretation has to be quite exact. There's no room for an extenso interpretation, but what the regulation indicates is that the notary should, in this case, include a clause in which the individual expressly refers to not choosing that law applicable to the succession, which will not affect the validity. On the other hand, when the individual wants to choose the applicable law, this statement should be added. If, however, the will is authenticated without such clarification, the regulation, in the arguments, in the preamble, says that the objective nature would not be sufficient, but the notary should have to determine that the deceased was presented to a conflict between the laws and willingly wanted to settle this conflict by choosing as applicable the law of his or her citizenship. On the substance validity, this of course is provided or in accordance with the legislation selected by the deceased. On revoking the applicable law, this will have to observe the formal validity on disposition upon death, and this will rely on the specific provisions to revoke it according to the law. Now, on inheritance, the deceased can choose the applicable law, but it cannot choose the forum to process the succession. With respect to agreement on competence, this can be concluded by the inheritors according to Article 5 in the regulation. So when the deceased selected the law applicable to the succession, the inheritors can set up can conclude an agreement in the sense of submitting or giving to the forum also competence on handling the succession. If this choice of the applicable law also impacts the competence on handling the case, according to Article 6, if the forum in the latest residence was informed by one of the inheritors, yes, there is evidence that the deceased selected the applicable law, and at the request of each inheritor, the informed authority can decline competence to the forum of the selected state, provided that it underlines that the forum to which the competence is referred to is competent to this, or is rather more competent to handle or process the succession. On the applicability or scope of the law, this is determined by Article 23. The succession law is general. It can continue with the rights, including on the liquidation of the succession. Obviously, most problems will be caused by conflict between law of location of the assets and the law of the forum, or between the law of the forum that does not know certain institutions provided by the succession law, such as the probate institution, specific to the Anglo-Saxon law. In the case of a conflict between the law of location of the assets and the law of the forum, this is quite a simple matter. Either a recognition of the effects of an authentic document or of a foreign judgment, according to Article 29 in the regulation, or if the law of the location of the assets doesn't acknowledge a right in rem that was applicable to the law of succession, then you have to adjust the rights in rem according to Article 31 in the regulation.
According to Article 24, something that was highlighted in the previous presentation is that the disposition of property upon death, when it comes to admissibility and merits, are subjected to the hypothetical inheritance law. This is a concept that the regulation has introduced. Right now, according to the Romanian law, we don't have that concept in our country. When it comes to the practical side of things, when you can settle an inheritance, the notary shall have to make a double determination. On one hand, he shall have to determine the hypothetical inheritance law that would have been applied if he had died when the disposition of property upon death was prepared, and the notary will decide whether the will is applicable and whether the basic conditions are complied with. And secondly, he will also determine or establish the inheritance law according to which the inheritance will be handled. When it comes to the distinction in between the will and the law applicable to the instruments contained in the will, the distinction, I believe, is important. When we have a character, a non-inheritance character, things are quite simple because instruments are governed by the law enforceable and applicable to them as per the private law. But if we talk about inheritance documents per se, the question is whether they are governed by the law enforceable to the inheritance or by the so-called hypothetical inheritance law. The solutions for the writs to be connected to the actual inheritance law and not to the hypothetical inheritance law seems to be strange to us, because we don't have that concept of the hypothetical inheritance law. But it is quite difficult to understand whether the validity of the validity will be governed by the law. When it comes to changing or revoking the disposition of property upon death, this is governed by the hypothetical inheritance law. On the other hand, we need to highlight that some effects of the disposition of property upon law are covered by the law applicable at the time of death, and all of these effects are lined up in Article 23. One interesting assumption is under Article 24, paragraph 2. The cuius may choose the law applicable to the admissibility and validity of the disposition of property upon death. I think that this provision actually repeats Article 22 at first sight, but this is not so. On one hand, if the deceased, the cuius, chose the law applicable to its inheritance, this chosen law will also govern the admissibility and the validity of the disposition of property upon death. But if the deceased does not want to choose the law applicable to the inheritance, but still wants to write a will that is valid according to the law of his citizenship, but is not valid according to the law, to the hypothetical inheritance law, so according to the law on the residence, then he will be able to choose the citizenship law that will only apply to the admissibility and validity of the disposition of property upon death, thereby making a valid option, but without applying the inheritance law per se. What are the conditions of substance that Articles 24 and 25 refer to? Just a couple of clarifications about point A, the capacity to dispose by will. This is about the capacity to attest and not the civil capacity. And this is governed by either the citizenship law or by the residence law applicable according to the private international law of that country. This capacity to make a will is valid through by virtue of the hypothetical inheritance law, which practically is about a compliance of the fact that the validity of an instrument needs to be appreciated in terms of the conditions that it complies with at the date when prepared. If subsequently the capacity to dispose is changed by the law, by a new law, that will still be valid. So certain subsequent incapacity will not affect that person's enjoyment, and tangibly this capacity, the notion as it is practically applicable in the field of minority. Traditionally, in the member countries, minors is entitled to a certain fraction in the will, starting with a certain age. This is going to be governed by the hypothetical inheritance law. If for writing a will by a minor, some form needs to be complied with, such as the authentic form, then this is a formal contest which is mentioned in Article 27 of the regulation, and it will be analyzed as per one of the laws that are lined up in Article 27. This provision, Article 27, refers to the conditions of form of the dispositions of property upon death prepared in writing. In this article, and in accordance with the regulation, we need to highlight that the countries that have signed the Hague Convention on conflicting laws regarding wills will continue to apply this convention, practically there is no major differences. There are no major differences. The difference still is that this convention does not regulate. Well, it actually regulates the dispositions, the instruments or agreements that had been made orally. Article 27 only applies to the written instruments. The dispositions of property upon death that are made orally are excluded, and this is not enforceable upon them. And the convention does not regulate the type of agreement to the succession. The question is whether the admissibility of such a will is a matter of form or a matter of substance. And the question begets different consequences depending on the jurisdiction where this admissibility is processed and regarded. This qualification, well, should it be according to the law of the forum, or should it be handled according to the modern method, according to which it is considered to be an issue associated to the inheritance? On the other hand, an interpretation and a solution which to my mind is logical and could be accepted by ourselves is that there should be a distinction in between the so-called mutual wills and the agreements as to the succession, because it's a matter of the fact whether the document can be revoked or not, because those instruments condition revocability on being alive or not. So when it is ordered that if somebody dies, then the will becomes irrevocable, then we can appreciate the validity of this will. The validity of the will is a matter of substance, so its admissibility has to be handled through the inheritance law, hypothetic inheritance law. The validity of this will is then established according to one of the laws that are lined up under Article 27. A mechanism that corrects that is the fraude à la loi mechanism. That mechanism only applies when we have a cross-border will. In this case, the validity of the will is not going to be processed through the angle of Article 27. When it comes to matters of substance, form, it has to be handled according to Article 34. To conclude with, you have here on the screen Article 83 that settles some transitory issues and enables the users to validate both the law applicable to the succession and also a disposition of property upon death before 17th of August 2015, according to either the conditions in Chapter 3 or to the conditions related to the residence. Thank you very much. I'm waiting for your questions. I would like to refer here to Article 46 and get some clarification to that. That law, in the Roman tradition, is a law that refers to inheritance and is applicable to a certain person. And according to that article, the enforceable law is the one of the citizenship of the deceased. It provides for an option to select the law according to which the accused was a resident. So it's the law of the countries where the deceased was a resident of. But also the situation where the deceased is not a resident of that country. So there is an option to pick up the jurisdiction which is quite restricted, because when the deceased died in a different country, he was no longer the citizen of his formerly home country, so to speak, former home country. And this is quite a different system. It's different from the system that Regulation 650 has introduced. Are there any further questions or comments from the audience, please? I participated in such a meeting before, and I have a problem. I don't understand something. According to the regulation, those who will apply the regulation must be public notaries that cover judicial procedures. We, the Romanian, if we, the Romanian notaries, do we have this sort of capacity? And I'm saying this because we were told in the previous training course that we should not be applying the Romanian law. And I have a problem. I have traveled a long way to ask this question. I don't understand. Yes, thank you very much. This is a very good question. I don't know why somebody tried to convince you that the regulation is applicable according to the category in which the national enforcing body is integrated. I would like to tell you that there is a distinction that was made in that training course where we participated referred actually to the enforceability of the jurisdiction norms. More specifically, those norms covered by Article 4 to Article 10 of the regulation. More to the point, when a court is seized with an inheritance matter, in order to establish whether that court is competent to handle that case or not, it shall have to apply Article 4 to 10 of the regulation. If a public notary is seized about succession, national succession, and a certificate is requested, or if a national succession is requested, not the European certificate, and if that notary is not a court and is not exercises its attributions as delegated by a court authority, then that notary shall not be bound by these jurisdiction laws. Because in order to release a national certificate or any other succession instrument, national one, the inheritors may approach the public notary from the country which is more convenient or closer to them in order to have their inheritance settled and in order to get this national instrument. But if we refer to the European Certificate of Succession, then the notary that will issue the European Certificate of Succession, well, there was a problem with the translation in the regulation here, and I don't like it, but anyway, if the European Certificate of Succession is issued, then the notary shall have to comply with the jurisdictional rules from the regulation. But I think that this was the distinction that was mentioned by the trainer. In all of the situations, the public notary shall have to comply with the regulation. Are there any other questions from the audience? I have a question. I think I know the answer, but I still want to ask this. According to this regulation, I, as a public notary, will be faced with a situation to handle a succession and apply joint will that is not acceptable under the law. I would like to know whether there is a chance that I be in a position to recognize, to admit a marriage of the deceased with a same-sex person, and if I can assign the quality of an inheritor to the surviving spouse that I don't recognize according to my own law. Well, the question seems to be simple, but the answer is not simple. Well, the testamentary contract is not something to be dealt with under the private international law, but the regulation is not mentioning anything associated to establishing who the inheritor is from the angle of the marriage. I mean, the marriage generates an inheritance. When it comes to divorce, this regulation is not very specific and explicit. The regulation conditions the pronunciation of a divorce on the existence of the valid marriage and provides some indications about establishing the validity of that marriage according to the law of the forum, while enabling the authorities applying the law of the forum to refrain from pronouncing a divorce if the marriage could not be recognized according to its own laws. But they can do that. They don't have to abstain. But the Regulation 650 does not cover the validity of the marriage. So, in my opinion, if the surviving spouse, who is of the same sex as the deceased in a valid marriage, is mentioned in the European certificate of succession, that will not mean that the authority of the respective state actually admitted and acknowledged that same-sex marriage that generated that inheritor and surviving partner. Actually, the regulation opened a little back door that our legislation could use. We have that unfortunate provision in the civil code that prevents us from recognizing same-sex marriages even if they are officially made in other countries in between foreign citizens, in order to be able to validate the rights of the surviving partner. So we have that problem in our law. Well, I should add something here about the possibility interference in between the personal relations and the inheritance law. The inheritance law is competent when it comes to the inheritors. The quality of inheritors is something preliminary that has to be decided beforehand. And in this case, it should be the law of the form should be applied. That will ascertain whether that marriage is valid or not. So the quality and the capacity of a spouse, according to the private international law of that system, is a matter that will eventually tell us whether that person is qualified or not under that law to be considered a spouse. But there are some limitations inherent in the public policy. Therefore, a value which is foreign or not embraced by a certain culture is introduced by this regulation. It's also a matter of how the family law applies in every jurisdiction. I think that somebody should react to these situations. And then, this is the argument which is the most widely debated in Europe, because it happens ever more frequently that people travel around. For instance, to Spain, and there are same-sex marriages in between local people and foreigners. I was talking about Spain, and this is permitted in that country. And therefore, this regulation has its own limitations. In Italy, there is the so-called Alfano directive issued by and initiated by the incumbent Minister of Internal Affairs. And this directive, requests from mayors to refrain from registering same-sex marriages that are made abroad. And some mayors do not comply with this disposition. Of course, that if two same-sex spouses, two Spanish same-sex spouses come to me, or two persons, same-sex persons who got married in Spain and get their habitual residence in Italy, under these circumstances, to me, this is going to be quite a delicate issue that I shall have to handle somehow. Anyway, this is the hot potato of the moment. A solution, a practical solution. After 27 August 2017, the same-sex spouse may resort to the so-called professio juris. Therefore, they may choose the law which is applicable to the inherited estate. And the Spanish law may be applied in this sense if they are same-sex partners. They have inheritance rights as anybody else, and these spouses inherit each other, and their inheritance statement or will be applicable in any countries. Even if they have some property, some estate in Romania, and if the certificate of succession prove that these people own the house which is located in a different country, then that estate is going to be transferred to the surviving spouse. Of course, there may be a moral thing here, but this is not a different sort of matter. Well, it's true that during the life the rights are not admitted for same-sex partners. I mean, one of them has to die before the other can do something. Well, I was saying in Romania. Well, if they get married in a European member state that recognizes the rights of the same-sex married couples, the problem is connected to the effects of the same-sex marriage, and these are effects that are to be encountered anywhere in this world. Any other questions from the audience? Well, if there are no questions, I would like to propose to take a coffee break, 10 minutes coffee break, and then we will be listening to a presentation devoted to the European Certificate of Succession. So please be back here at 12 o'clock. Thank you.
Cred că putem începe cu ultima prezentare a
I think we can start with the last part of the first session of the seminar about the certificate, the European Certificate of Succession, and we will be hearing from Mr. Lorenzo Praz-Albentosa this presentation. Hello, thank you to the Union of Notaries in Romania and in Italy and of course to our colleagues that have introduced us. Well, my presentation covers the European Certificate of Succession. Now, how the notaries are involved in this issuing of the certificate and to enforce the law, because they are the most important institutions to be processing basically this certificate. I have 32 slides, quite a lot in number, but I will try to focus on the most interesting matters, in my opinion. And maybe in the afternoon we will be able to tackle more practical details that unfortunately I do not have the time to get into right now. Mainly, as known, Article 62 and 73 in Regulation 650 speak about the European Certificate of Succession. The greatest novelty that this regulation brings is that it's pretty much like a passport. It's even considered to be as important as a passport. Therefore, Regulation 650 stipulates a very formal procedure for the recognition of the inheritors, the legatees, the administrators, appointing them as such in these capacities, within a European Certificate of Succession. The law or the legal matters on who is the inheritor or not, who is the legatee or not, are down to statements according to the succession law. Inheritors, according to the applicable law, are determined as such according to the general legal framework. So in this case, the legatees or the heirs or the administrators of the estate or executors can ask the judicial authorities or other authorities for that matter for the issuance of the European Certificate of Succession. What should the competent authority do according to the law? What should the authority appointed by the member state do to issue the European Certificate of Succession? The authority must request for evidence on the authenticity of the statements of legatee, of heir, and whatnot, and it must be certain based on other argument and other evidence as well, until being able to conclude that the applicant for such a European Certificate of Succession is the one that, according to the regulation, is entitled to be heir to that estate. Now, in order to apply for the certificate to be issued, certain forms must be filled in. For this reason, the European Official Journal, dated December 2014, published a regulation on the execution of this matter, Regulation 1309, where the applicable legislation can be applied with respect to the issuance of the certificate, the forms, and the paragraphs applicable for requesting the issuance of this certificate. Form number 4 and form number 5, more particularly, and all annexes. Very many pages. I couldn't really write all this information on the slide because it is quite complicated. As I said, there are quite many. However, we have the official journal of the European Union dated December 2014, as I said. This is studied in Spain for the notaries because Spain informed the European Commission that according to the judicial authorities, notaries will be those appointed as competent authorities to issue the European certificate of inheritance, of succession. This is why in Spain, the notary is the main authority for the that the European regulation focuses on with respect to the issuance of the certificate of succession. So, we believe that notaries are those that know more details about the succession law. Well, in Spain, citizens are used to go to the notary when they have an issue with respect to the succession or with respect to the will. Therefore, the issuance of this European certificate of succession is the proper and a practical way of putting in practice basically the applicable legislations. And all this refer to the practice of the notaries. The forms have to be known very well. All the practical issues with respect to the forms have to be known quite clearly. Why? Because the passport of the inheritors is a public document. The suggestion of our government for the execution of this right with respect to the Spanish legislation is that the European certificate of succession issued by a Spanish notary should be a public document. This is why it has a very clear definition or representation in the legislation, but it is also acknowledged abroad because it's of a public nature, issued by a public authority, the notary, and it is valid at the level of the entire European Union, as per Regulation 650. But, again, coming to the Regulation 1215, per 2012, the provisions are also applicable in this case as well. And for a quick explanation, all these slides basically present the most important matters or aspects that I've thought of with respect to the applicable legislation for the certificate. So, since it's a public document, it certifies and attests that that person is the heir. This is important in the European Union because it attests to the rights and to the shares of the rights as heir legatees, as stipulated. So awarding the inheritance to the heir, to the legatee, to the administrator, to the executor as applicable. Now, who is the competent authority to issue the European Certificate of Succession? The main authority, according to the regulation, consists in the judges. Well, not just the judges. Member states are now those that will decide which are the other authorities, not just the notaries, because other such authorities may issue the certificate in question. In Italy, this the only authority would be the notaries and not the judges. Well, this might be an issue because the regulation does not exclude the judges. On the contrary, it quotes them specifically. I think it's a matter of applying or enforcing the regulation. Well, there must be a law or an order to enforce the European legislation. Well, it's not the competence of the internal legislator to rule on this. That is why I believe that the regulation quotes directly the judges. Well, maybe we can tackle this approach afterwards during the break. So, judges and other authorities. Lawyers, legal professionals, apparently they all have the competence to issue this certificate. So the judicial function acts as a judicial authority or under the control of a judicial authority. The regulation itself stipulates clearly that if not a judge, then in this case, this member state can appoint another authority, be it in the sense of legal professionals like lawyers, for example. But this depends on each member state. However, the principle of impartiality has to be observed, because the regulation states that the decision on issuing the certificate must be the object of a review before a judicial authority, and this decision will have the same effects as a decision of a judicial authority on the same law matter. So, protecting the rights of the interested parties in issuing the European Certificate of Succession. The protection of said rights by the authorities and the professionals appointed by the member state to issue the European Certificate of Succession. The authority of the member states is the one competent to inform the Commission on which are the other authorities that can issue the certificate. As I said, in Spain, the Commission was notified that the notaries will also be those to issue the certificate. The request, the application for the certificate Article 4, I hear, from Regulation 329. So I think there are 6 annexes that refer to this in particular. No, form number 4. Here you see all these annexes. When the application is received, form number 4 is filled in and submitted with the competent authority, be they judges or another authority. The competent authority has to start the procedure to check the details, but not just checking, but it also has the possibility to ask for the necessary inquiries to be carried out to see whether the applicant of the certificate is entitled to receive the respective certificate. The competent authority can ask the applicant to provide evidence required to attest to this capacity. The authority can also ask for other means of evidence to conclude on the fact that the applicant is entitled, as we said, to ask for the issuance of the certificate. Another important matter, because we do deal with practical details. An heir coming to Italy or Romania saying that according to the Spanish law, I'm the heir of my father. And given my capacity, I have assets in Romania and I want to receive my European certificate of succession. The competent authority not only has to pay attention to the request, but it also has to inform the other heirs, my brothers in this case, that they're also entitled to this certificate. And the authority has to inform the other siblings that one of them has asked for the issuance of this certificate of succession, so as to avoid cases in which the European certificate of succession might jeopardize the rights of the other heirs. And therefore to give the other beneficiaries the possibility to claim their rights. The competent authority can ask the competent authorities of another member state in their turn to provide information or evidence documented by the land registry, for example, or by the civil status registry, or other authorities that can issue such documents attesting to the information that the applicant has provided. Now, finally, if the authority concludes that the applicant can be issued the certificate because he or she is entitled to it, sends in the end the European Certificate of Succession. This is form number 5 in regulation 1329 for implementing it. Form 5 and all the annexes of this Form 5, I think there are 6 annexes. Here you see the details with respect to the applicant. There is a decision of the authority, and the decision which is very important because at the end it will issue the certificate, as I said, that also is regarded as a passport, and the legatees, heirs, executors, administrators can attest to this and justifying that the title is received according to the succession applicable law. The effects of the certificate. Basically, would be that they attest to the fact that what the individual is saying is true, and it's quite a strong proof of authenticity. The certificate, as I said, can be used as evidence to attest to this capacity without resorting to any other formality or procedure. And the ex-quater restriction. This no longer exists basically in the European Union. This is a matter of history now. The basic principles of the European Union in this case rely on trusting the state. Secondly, the certificate is not an enforcement, but it does have a very important effect because the proper title to document inheritance rights belongs to the member state. So the citizen in Romania married in Spain, deceased in Spain, where the succession law is the Spanish law, because the choice of law was after August 17th, the wife in this case can apply for the European Certificate of Succession to be issued, attesting to the fact that her husband owned an apartment in Bucharest. She will show the land registration office this European certificate for the asset to be registered on her name without any other co-validation or co-checking procedure of the European Certificate of Succession. So it can be used, as I said, as evidence attesting to this capacity. Two important assumptions. Person or individual acting based on the information from the European Certificate of Succession. If they inherit an asset, this inheritance has to be reviewed from the perspective of its legitimacy. The individual is attested according to the European Certificate of Succession to pay for the succession in question and to having received these assets. So the action was based on goodwill or acting in good faith. If it doesn't act in good faith, then the certificate would not have these effects. I apologize. Basically, this is the information that I'm hearing. So the presumption of having purchased the assets in good faith, the individual purchasing inherited assets with the capacity to alienate them upon receiving the assets, either based on good faith or according to the certificate, the purchases according to the bona fide. Exception to this, had they known the content, or whether they knew that the content does not match a reality, or that it did not know this, then ignorance, however, does lead to consequences, because Form 5 is an original document, a public document, according to a judicial decision, or in my country, according to the decision of the notary, a public document, as I said. It's an authentic document, and the authentic document is the one that the original of this authentic document is kept by the notary. The judge will send a copy of that certificate, but the original will always be kept by the archives, the archives of the notary, or by the archives of the authority competent to issue the certificate. Now, this authenticated copy has a clear validity of 6 months. 6 months because the applicant in this time can set up all the other activities according to their capacity as heir, legatee, executor, or administrator. After 6 months, this validity of this copy expires, but prior to the expiry, an extension of the validity period can be requested. If the competent authority so deems, the validity period can be extended for another 6 months. So there is no limit to the number of extensions. So extension after extension can be requested as long as the heir, legatee, needs this in order to have the new asset registered on their name, or to apply to enforce the obligations resulting from this from their capacity attested by the certificate of succession. The regulation also provides that if the succession is complicated, the authority competent to issue can decide that the validity of the copy of the certificate not only be set for 6 months, but for a longer period in case of a complicated or a complex succession. Of course, this decision will have to be argued and at the end and motivated, and at the end, and on form number 5, there has to be a provision stating that the copy is not valid for 6 months, but for 1 year or 1 year and a half. And therefore, the request can be made for a validity longer than 6 months. This is decided so, as we said, the certificate can be valid for 12 months in this case, and prior to the expiry of the copy, the heir can ask for an extension, but not for another year, but for another 6 months, because this is the main validity period that the regulation has determined for these copies. However, this does not prevent the heir, the legatee, the executor, or the administrator to ask for an extension for a longer period of 6 months. Arguing, explaining the reasons for which this request is made for a longer validity. And the competent authority can decide whether to grant the extension of this validity of the copy for 6 or 12 other months, depending on whether the applicant is entitled to ask for this extension.
Well, according to the regulation, the effects of the European Certificate of Succession can be suspended. It also goes about the protection of third-party interests if requested by those who can prove that they have an interest to have a succession certificate changed. So it can request from the authorities to suspend or discontinue some of the effects. Why? Well, this is something that we need to discuss during the afternoon session, because the court authorities are also authorities that revise and make decisions jointly with the other authorities that can issue this European Certificate of Succession. Then the notary's decision is not a decision which is unappealable, but is a decision which can become subject to an extraordinary appeal submitted to a court. In the meantime, it is decided to suspend the effects of the European Certificate of Succession. This suspension is granted by means of a communication of a decision to communicate the effects to all of the people who have a copy of that European Certificate of Succession. In order to change the assumption related to the principle of good faith, the principle of the bad faith, malafides, will be applied in connection to the effects of the Certificate of Succession, and therefore this will not be applied according to the good faith, but according to the bad faith principle. These are matters of material errors. So the authority will then be capable of revoking further to a request or they can change or revoke the European certificate if this is requested by the national law. This is the basic presentation of the European Certificate of Succession. It is not difficult to understand the sense of the regulation and the effects of this certificate. An interpretation may be done. The principles of normality can be construed one way or another. Normality is not something that happens right now. Normality will happen in a few years' time. I can talk about my country, Spain. Well, there is a small laboratory of civil law in my country. And the European Union talks about the rights of citizens, it's about the civil law. Well, in a couple of years' time, we will be seriously talking about these issues. And we will also be talking seriously about civil law in Spain, inheritance law in Spain, and also about the 7 enforceable laws in this line of work. We need solutions to apply the enforceable law. But, well, we have some federal authorities. The federal authorities are the courts of first instance and the private notaries that deal with inheritance laws. Our notaries are the ones who are competent to handle the successors' statements. This is a public document. This public document, which is an instrument that any competent notary can prepare, will have effects anywhere you go in our country. So the notary who requests from the person who wants to have a will, once that person is identified positively, the notary will proceed and try to set connection in civil terms to a real person. I know about the civil law applicable in Catalonia, and a person can express its own will according to this law from Catalonia, and the notary from Spain can call one of his colleagues from Catalonia and say, okay, I'm from the Andalus region, I have a problem with this particular thing from your own region. Are you aware of any problem about this person? And the peer from Catalonia said, no, I don't have any problem. I know this guy, this is an inheritor, and so on. And you can proceed because he has a son, he is over here, the son is over here. And so that instrument is a public instrument that can be invoked and presented anywhere in Spain, and it will entitle the holder to all of the inherent rights. And that's with the European Certificate of Succession as well, because essentially this is a certificate that has the same effects that our statement has in Spain. Our statement, which is notarized, and this has an effect even if presented to judges and to courts. So the notaries issue this statement, and it refers to legatees or to inheritors. The notaries are unable to always formalize somebody's capacity of a legatee or of an inheritor. If there is a will, well, that's fine. But if not, there is a civil procedure whereby the notary can declare if that person requesting the inheritor statement has the right to get or not this capacity of a legatee. Well, that's much. That was with my presentation, and then I will be waiting for your questions. I will be waiting for your practical questions. Well, Lorenzo, of course I have my own ideas about that. The Italian law assigned the full jurisdiction to the public notaries, because Law 64 of the regulation establishes who applies the rules. It is a court or any professional. So there is the word "or" there, and based on that "or," you can choose one or the other. And in Italy, the public notary made the public notaries made every effort in Italy to be them who handle this. There was some article in the old days, but the Italian court judges have a big caseload to handle. They are always busy. So the Minister of Justice from Italy stepped in and said, okay, we need to relieve some of the judges from their caseload. They should be handling this. The public notaries will be just fine. That was a little bit strange, but this is what the minister said. So now the notaries handle this problem. And the European Certificate of Succession, in Italy at least, is not a public instrument, as far as I'm concerned. It's a notarial instrument, which contains the expression of somebody's will, but has the power of a court decision. So basically, it is not an authenticated instrument per se, and it is so in order to enable the notaries to act in the cases which you described before. In this way, the notary will not confine himself to handling the will, but the notary will also make a little bit of an investigation. And the notary can use, in this respect, a couple of tools that the judiciary usually uses in order to run this sort of investigation. Who is the legatee, who is the inheritor, who is the executor. That's my personal interpretation, of course. But since the Italian law relies on that word "or," well, this sort of assignment has been given to the notaries. Yes, we can also talk about that. We can talk about other issues as well. The notary is basically an organ of the jurisdictional competence of the legal system. We have a draft law about this particular relationship. The notary is the main organ of the voluntary jurisdiction, but they still work as notary, because what does the notary do? What does the judge do? They both generate public instruments, official instruments. So there is a procedure of voluntary jurisdiction. This is what happens when the authority handling the case is the notary. And the consequence of the whole procedure is a public instrument. And for that matter, we say that the certificate of succession, the European one, according to the Spanish draft law, is a certificate of succession which is valid, is issued by the notary, is a public instrument, and well, that is also important for something else. It has another effect as well. There is also that inheritor's statement that is effected internally or nationally. For instance, a Spanish person who died in southern Spain, and his inheritors request that certificate of succession, they request to see the will, and they request to see the deceased statement. These are all public documents, public instruments. The statement of the successor is valid within Spain. If we want to have a statement which is valid in other countries, for instance in Italy, because the deceased may have some property in Italy, then how should we proceed after August the 17th? So we have this statement of a successor, this public instrument as I named it, then we transposed it into a European certificate of succession. So there are the same effects, the same qualities. It's a public document, public instrument, and it generates all of the effects of the certificate, which is issued by a notary. Well, thank you very much. Mr. Lorenzo Prats Albentosa. And since we are a little bit behind the schedule, I suggest to take the lunch break and to get back here at 2, and then we will resume the talks and the questions. Thank you very much.